One of the things I'm intentional about with Behind the Bar is bringing you lawyers and other professionals who don't just practice law, they shape it. Lawyers who've built something meaningful, sustainable, and respected, and who can give you real insight into how to build a career with both excellence and confidence. Today's guest is exactly that kind of lawyer. I'm thrilled to share Mark Tweedy, KC, with you, and that KC matters. Mark was recently appointed King's Counsel. This is an honor reserved for a very small percentage of lawyers who have demonstrated integrity and exceptional skills and a contribution to the profession. Mark began his career as a litigator in 1982 and spent many years in the courtroom before transitioning into what has now become a thriving and highly respected mediation and arbitration practice. He did his first mediation as counsel in the early 1990s, his first mediation as a mediator in 2004. He conducted his first mediation as counsel at a time when mediation was really still just emerging. It's not mainstream as an option as it is today. And in many ways, I believe that he helped shape the path forward for mediation becoming what it is today. He has conducted more than 2,000 mediations, and also works as an arbitrator. He currently mediates complex, often multi-party matters across Canada and abroad, focusing on aviation, commercial, construction, personal injury, sexual abuse, class action, and mass tort cases. These are sophisticated, high-stakes matters. And what I love about this conversation is it's not just about mediation, it's about professional evolution. It's about seeing an opportunity in a changing legal landscape. And it's about understanding how you, as a law student or a junior lawyer, can show up meaningfully in a mediation, because you will probably be in one at some point sooner than you think. So we're going to step into the mediation room with Mark. He's going to talk about what really happens there, what senior lawyers expect, how junior lawyers can contribute, and how you can begin building the kind of credibility that over time leads to a successful practice and possibly a KC. If you're considering litigation, dispute resolution, or simply want to understand how strong lawyers build long-term respected careers, this one is definitely for you. I hope you enjoy it. And if you know someone who's thinking about litigation or mediation as part of their future, please share this episode with them. Enjoy. Welcome to the Lawyer Launcher Podcast. Hello, friends. I'm your host, Susan Van Dyke. If you're a law student or a new lawyer eager to launch a successful career, you're in the right place. Drawing on more than 25 years of experience, I'll demystify the business of law and help you understand just what it takes to succeed. We'll empower you, help build confidence, and reduce anxiety. Our experts will share tips and advice, and I can't wait for you to hear from them. Now, let's dive in. Mark Tweedy, welcome to the Lawyer Launcher Behind the Bar podcast. So good to have you. Thank you so much.
Good morning.
I am so excited about bringing law students and new lawyers into the mediation space with you. People already know what you do. We already know how experienced you are, but I want to set the stage. And I'm going to ask you to kind of take us into the mediation room. What does that look like? What are you doing as a mediator? What are you seeing as the parties filter in? Can you take us into the actual space and set the stage?
Sure. So I have two rules with respect to sort of that aspect of things. The first is, my first rule is I am the first to arrive. And related, I am always the last to leave. And we can explain why last to leave in due course. But I'm the first to arrive, and there's some very practical reasons for that. First of all, a mediation typically takes place in one of two locations, either a court reporter's office, which is set up for space, or alternatively, a lawyer's office. That said, some notable exceptions in my career are once I did one in a curling club, and and once I did one using a bar in a small town hotel as a breakout room on a day that was closed. But regardless, the norm is typically court reporter's space or a lawyer space. And there's two reasons that I arrive early. And the first is I want to greet people. A large part of my job, to put it as basically as I can, is to put people at rest, make them feel at ease, and that's all a process of helping build a level of trust with them if I don't know them. Often I'll know the lawyers, sometimes not. Frequently, I won't know the parties themselves. So that's part of that. The second thing is really practical, and that is when I show up and I've got 10 people coming and the room holds 6. Or I show up and I need 4 rooms and I've only got 2. So those sorts of things you could describe them as blips, but the fewer blips I can have in my day, the better off I am. So I arrive early. I'm first to get there. So what will happen is I'll arrive early. I'll get set up, which means get my laptop out, get my little remarkable out with my notes for the day, make copies of anything I might need, for example, a mediation agreement, and I'll greet people as they arrive. And if necessary, I'll do introductions for unsophisticated parties, which I'll often deal with. I wouldn't say make light, but I'll try and make small conversation with them and make them feel relaxed. And that'll sort of that's what I'll do until everybody gets there, and then I'll have a joint session typically.
So I'm hearing you talk about almost being a host, like you are literally setting the stage and you're taking responsibility for, even you're not above making sure everybody has a seat, rolling seats into a room to make sure there's enough seats, making sure you have hard copies and whatnot in the space to make sure that you're ready, and you're taking real responsibility for being ready for the parties to come in, making sure you're setting the right tone, not overly friendly, but trying to get people to relax. I love that, because I can imagine as the parties, even the lawyers themselves might be a little bit nervous. Maybe some lawyers haven't actually engaged in a mediation with their clients before very often. So they're maybe coming in feeling less prepared than they would for court. So I love that idea. And the taking responsibility, I think, is really important, and that you're not above anything, that you're taking.
Oh, and it's people are hiring me to guide them through this process, often to create a process and then guide them through it. And part of that very much is setting the stage and making sure they're ready to engage in the process. Simple things like, would you like a coffee? The coffee machine's right around the corner. If the snacks aren't out yet, they're coming out. They'll be very shortly. And by the way, the croissants are very good. Those sorts of little, like dropping little breadcrumbs at the beginning to show people I'm there to work with them.
Right.
And I'm there to assist them in doing what they have to do that day.
And actually, it just occurred to me, Mark, that the same could be said when you're hosting, because you've practiced law in a law firm as well. The same could be true when you're welcoming a client into a boardroom for any meeting in a law firm, that you're hosting. Sure. And all of those things are.
Yeah, you've hit on something that I think I forget from time to time, and I think lawyers forget from time to time, that the space, the mediation space, and I don't use that in a physical sense, but the process is something that many of the participants, the lawyers and the mediator, and if there's insurance people or claims people from large corporations or whatever, they engage in it all the time. But for some of the people, they don't. For many people, it's their first go. And that's a question I'll ask unsophisticated litigants. Have you done one of these before? Yeah, I did one for my divorce. Well, how did that go? Or no, I never have. And I'll usually say something like, this is a process. Please try and stick with it. You're in very good hands today. I've known Bob, your lawyer, or Jill, your lawyer, for many years. You're in very good hands today. Those sorts of things. Make people feel like they belong, as opposed to this is something that's being, they belong and they can participate, as opposed to something being forced upon them.
And you are just now illustrating what I've always said about you, Mark, is that it's your emotional intelligence and your ability to read people and your interest in people's well-being in that psychological space, I think, is part of the key, aside from all the many, many years of success and your technical knowledge, of course. But I think it's that emotional intelligence is one of your superpowers. And I love that you just shared that. Yeah, and I think I've seen it as somebody who's known you for many years, for sure.
Yes, thank you.
So over the years, we've seen mediation really grow in practice. I mean, when you first started, it wasn't as common. I know you were doing a lot of training of lawyers and going into firms and talking about what does this look like, and we're going to get into some of that today. But I actually tried to pull some stats on how mediation has grown, and there's nothing really specific. There's no specific data, but I did get some trends, and I saw that a 2025 survey found mediation remains the most used ADR, alternative dispute resolution, ADR, method, with 87% of attorneys, so this is US, of attorneys reporting they used mediation most often, and nearly half using ADR at least monthly. So that's in the US. That was really surprising. And then in Canada, an arbitration survey, so this is arbitration, found that 71% of law firms reported 10 to 25% growth in lawyers doing ADR work. Does that ring about true for you?
Yeah, I think, and as you know, and as your lawyers have heard, I've been at this a while, and I mean, it's changed, right? When I first mediated back in the late 80s or early 90s as a lawyer, the mediator would actually phone up. It wouldn't be uncommon for the mediator to phone the lawyers and say, I'm phoning you about the Smith and Jones file. Sally on the other side wants to mediate this case. What do you think about that? And there'd be this process to get people to say, yeah, we'll do that. And it's become, in part through legislation with the notice to mediate regulations and so on, which come much later, but it's become in this jurisdiction a very, very common step in the litigation process. To my observation, people have over the years, I'm sounding like back in the day guy, but which I don't do. But back in the day, it wasn't in the lawyer's typical toolbox. And now I see counsel, really skilled counsel, have figured out how to act as advocates at mediations as opposed to standing up in front of a court or a tribunal or at a hearing or whatever, and approach it differently. So the skill set has risen and grown dramatically, and I'd say even in the last 10 years, to my observation.
Right.
Lawyers have become much, much better at it.
So they're more familiar, they feel more skilled, they feel more comfortable, they feel like they can support their clients more effectively. So maybe that's why they're,
Absolutely.
Yeah. So they're coming to the table more willingly.
Yeah, and I think it's two. I think it's it's one, trust in process. They trust in the process because they've seen how the process works and how it unfolds and the advantages to it. I also think, and I'm not alone from my discussions with other mediators, most of the lawyers that 90% of the time on any given day, I will have dealt with the lawyers or their firm before. So there's this trust level that builds up between counsel and the mediator. And I'm not unique in that. I know from talking to other mediators, they have regulars, people who regularly engage them. And that's really important too, this trust piece between the lawyers and the mediator.
Because both parties are choosing you. Both parties are agreeing to a mediator or their arbitrator, and you do some arbitration, I believe. So both have to agree, because if both parties don't agree, they have to go and find another mediator, arbitrator, right? Yeah. Okay. So let's actually get into what is a mediation. You said there's a process. Can you take us at a high level? And maybe there's different processes for different types of disputes, but just take us through what a junior lawyer or an articling student or an intern, what do they need to know about the mediation process, Mark?
I think the starting point is with qualification, because nothing's ever certain in this world. It's at heart a voluntary process. You can compel it through the various notice to mediate regulations. You can compel the appointment of a mediator if you can't agree on one. But at its heart, it's a voluntary process, and people have to be willing to, even if it is compelled, they have to be willing to engage to have a meaningful discussion about resolution.
So it has to be
So
persuasive, a persuasive
that's
process.
right.
Yeah.
So that's kind of the starting point, that it's this voluntary process. The other starting point, and it's perhaps obvious, but I'll say it anyway, it's a voluntary process guided by a neutral third party. And the neutral third party is the mediator. And the mediator's role, and this is part of what I say when in a typical introduction to the parties, even though I'm a lawyer, I'm not here to provide any legal advice. Even though I'm an arbitrator from time to time, I'm not here to make any decisions. And God knows I'm not here to tell anybody what to do. My job is to facilitate discussions between the parties with a view to resolving the issues in dispute.
I'm going to interrupt this interview for just a second because I need your help. This podcast takes a lot of energy, a lot of resources, a lot of time, and I need something small from you, please. I need you to subscribe to this podcast, either on YouTube or your podcast platforms. I would love for you to like, I'd love for you to comment. And I'd also really appreciate if you share this podcast. We want to reach as many people as possible, help as many new lawyers, law students, interns, summer students, the whole bit. I want to just get this podcast far and wide as much as possible. And if you're watching from a law firm and maybe you're having your lunch and you're listening in as a group, that's fantastic. And I hope you get all the CPD credit that you need from this episode and from future episodes. So before we carry on, please take a moment and share this episode, subscribe, like, comment. I need your help, and I really, really appreciate it. Thanks for listening.
So those are sort of that's really at the core of it, I think, from a process point of view. Voluntary, guided by a neutral third party who doesn't have the authority to impose an outcome. The outcome is one created by the parties. And that, without getting all kumbaya with you, is a very empowering thing. Yes. Remember, I was a trial lawyer for many years. Mm-hmm. When people stand up before a judge, mm-hmm. what they're really doing is they're saying, Judge, we don't know how to sort this out, and we want you to sort it out for them. And then what happens is the judge ultimately sorts it out, and he tells the parties, this is the outcome. Mm-hmm. And 9 times out of 10, one side doesn't like the outcome. Mm-hmm. A mediated process, a mediation or a negotiation allows parties to craft a solution that they can live with, as opposed to having one imposed upon them by somebody else that they don't like. So it's very empowering, and it's empowering, one, and two, particularly in certain types of cases, it allows parties to come up with solutions that a court can't. That's particularly true in shareholders type cases, estate type cases, a whole range of cases where a court can only impose one sort of outcome, and the parties can say, no, we'll decide to do it this way. Mm-hmm.
What have you seen from the counsel's point of view? Do all parties have counsel present?
In my mediations, yes, because I typically don't work with unrepresented parties.
Okay. And then how often
but there is a whole sphere out there where there are not lawyers involved.
Okay.
It's just not something I do.
So since we're talking to articling students, interns, and new lawyers, we're going to talk about the space that you're typically in. What have you seen in terms of what kind of influence does counsel have? What is their role? What have you seen work well? What have you seen that derails the process that you've so carefully set out? And then my third, I can see you. And then the third question, really, part of that is, where does a new lawyer or an articling student, where do they fit in? Do they fit in? Do they observe? What can they, I think it'd be so cool for a new lawyer to go in and observe a mediation in preparation for bringing their own clients into a mediation space.
Yeah, I think the role of lawyers obviously is to advise their clients. I think the really important function of a lawyer at a mediation is and lawyers do this anyway, is to analyze risk on behalf of their clients. No case is risk-free. Some cases have more risk than others. Certain issues inside any given case might have more risk or less risk than other issues. I think the process, a resolution process, is at heart a risk-driven analysis. So, in other words, the lawyers are going to assist the parties in saying, you know, if we go to trial, there's a risk a judge may not accept this, or make it very simple. There's a risk the judge may say, no, Mr. Smith didn't run the red light. Mr. Smith stopped, you ran the red light. So that's where lawyers are very, very helpful. Where lawyers get in the way, in my experience of a resolution, is when they take positions that are unreasonable positions, meaning they're not analyzing risk, or they're not listening well to what other people say their risk is. I've never, in all the mediations I've done as a lawyer, which is a few, and all the mediations done as a mediator, which is a few more, I've actually never been in a mediation where 3 hours in, someone says, you know what, I've been listening to you for 3 hours. I now think you're correct. That doesn't happen at mediations. What happens is that 3 hours in, from time to time, people will say, okay, I understand what you're saying. And they may not say it to me or to the other side, but they'll go, okay, I understand what you're saying now. I see where I have a risk that might happen. I think you, my client, should have tried to avoid that by doing something different.
Is the lawyer
That's what I think drives the process.
Right. Okay. So, but the lawyer's role then, are they speaking out loud? Are they taking their client into another room? Are they whispering to their client?
Yeah. So back to sort of what to expect in a typical mediation. Our jurisdiction, we still do joint sessions at the beginning. The US, they don't do that anymore, and they're uncommon in Europe, I'm told.
So that means they're in two separate rooms, right, Mark?
Yeah, they start
mediation,
the US
going back and forth.
Yeah, US, the model has become no joint session, mediator shuttling back and forth.
Really?
I do a joint session almost always at the beginning, unless there's good reason not to. Sex abuse cases are a good example. Often a good example. Sometimes the plaintiff wants to be in the same room as the perpetrator, sometimes not. But unless there's good reason, I'll do a joint session. And I'll also, through the day, depending on where we're at or what's going on, I might do a further joint session where I think it's useful to have a further discussion about particular issues to try and move this risk piece, as I described.
So as a mediator, you're looking at your process, you're observing the parties, you've got a lot of things running in your head at the same time concurrently, because you've got a goal, you're hoping to obviously find resolution in this, but you're actually sensitive also to what's happening with the parties, their emotional states.
Totally.
And then the lawyer, the counsel as well. What is the risk? Are they interfering? Are they helping and doing whatever you can? I don't know if you can influence the counsel's participation.
Sometimes.
Can you? Yeah.
Sometimes.
Yeah.
Discreetly, quietly.
And hopefully they're observing that too, right? Hopefully because their interest is having their client find resolution.
Sure. And again, I'm very grateful, and I'm very fortunate and very grateful for the fact that I tend to work with very skilled people. And skilled people will know what they don't know, and will say, okay, what do you think about this? We're at this juncture here. What do you think? Should we do this? Should we do that? I'm thinking of doing this. What do you think about that? And so there's this, and I'll engage with them, and they'll engage with me as to what comes next and how best to do it.
So the lawyers in the room, they're hopefully listening to the subtle cues that you're giving.
Yeah, sometimes subtle cues don't work. Sometimes sometimes you have to be less than subtle.
Less than subtle.
Be less than subtle. That's right. It's one of
But
my
they're
it's one of my tools.
but they're respecting your position as the mediator, who they've hired and put their trust in.
Sure.
So, even if you have to be less than subtle, hopefully they're taking those cues and actually leaning in and participating in their client's outcome.
Yeah, I'll give you a good example. I had a discussion yesterday with a lawyer that I've done more cases, serious cases with wrongful death cases, sex abuse cases, catastrophic personal injury cases than I have fingers and toes. And we have an ongoing matter where there's dozens of plaintiffs. And we did a round in 5 days in Toronto, and it didn't go really well. And we've been trying to figure out what to do next and how to do it. And there's a bit of a difference. I shouldn't say a bit of a difference. He's got some views on what he wants to do now. And I'm very respectful of those views. He's the lawyer, they're his clients. He's got an obligation to do what he thinks is in their best interests. I found myself a little bit yesterday kind of pushing back on a little bit of it. I say, okay, I get that. What about this? What about trying this with these cases? What do you think about that? Because we made some progress, we didn't make a lot, and this and that and the other thing. And it was a very respectful discussion. We're on the same page. We're all the same goal to try and resolve all these cases. And he said, okay, you know what? I'm going to talk to my co-counsel, and I've got some expert stuff coming in that I got to deal with on all this. And why don't we touch base again next week? So it's I settled a bunch of cases with this guy years ago, and we all went out. All the lawyers and myself went out, and we settled these 8 cases. It took us 16 months to settle. And the same fellow remarked what a pleasure it was working with a whole bunch of people who are on the same page. And the same page is to resolve these cases. So different ways of doing things, right?
And those that know, you're going to be creative, right? You're going to be creative. You're going to find ways.
Yeah. I can't. And I can't imagine anything more boring, and I wouldn't want to do it, than being the mediator who runs from room to room and says, no, so your next offer is $100,000. Is that plus costs? And a glorified note taker. Like, I don't want to be a glorified note taker or message runner. I have no interest in doing that. So I seek out work, and I seek out people who don't want to do that.
Right. Because when you're in the room with all the parties, you can see all the body language. Sure. You can see everything happening in real time. Let me switch focus here, Mark. So thinking about the law student, the articling student, the junior lawyer who's supporting the co-counsel, as you say, or the junior on the file, what is their role? Are they preparing their lawyer and their client for mediation? Are they doing research? What can they do? What should they do prior to mediation? And then what can they do in the room during a mediation?
So I think I'm not going to dodge the question. I think if you're a student or a junior, you should ask the senior lawyer what it is they want from you.
Yep. Get instructions from your lawyer.
And go from there.
Yeah.
I think, my experience, again, lawyer for many years, junior lawyer for many years. My experience is not to assume. My experience was it was not good when I assumed I either had responsibilities or conversely didn't have responsibilities in any given matter. I think clarity as to what the role should be is paramount. And if in doubt, when you're actually in the process, if in doubt, make the inquiry of your senior discreetly.
Right. So that's a very reasonable bit of advice. So prior to the mediation, ask your lawyer what you should be doing, how you can help,
Right.
if at all, prepare. And then perhaps the same is in the room. Ask the lawyer, what should I be doing? Should I be taking notes? Should I be just observing?
Right.
What
Right.
do you see many juniors involved? Do you see, because I'd like to think that a senior,
Often.
you do. Oh, good. Yeah. Okay. That's
Often.
excellent. Yeah, that's excellent. Because as we see mediation increasing in frequency and senior counsel becoming more comfortable using mediation for their clients, boy, what a lost opportunity not to bring a junior in the room or a student in the room.
Totally.
Yeah. So would you say 50% or more of the juniors are getting in the room?
Is probably higher. For me, the more complex the matter, the more likely there's going to be more than one lawyer.
Okay. And those juniors, are they sitting directly at the table? Are they taking literally a back seat?
They're engaged. Often, my experience, the junior will have had not a fair level, but ongoing contact with the actual client prior to the mediation. So they're going to be there and engaged. They're going to know the file as well as the senior.
So the invisible work, we talked about the invisible work is what matters most, the preparation of the client, the support of the client. So the junior may or may not, hopefully they get an opportunity to do some of that invisible work. Anything that you've seen that didn't work well, a junior's well-meaning approach, maybe they took too much initiative. Have you seen anything where you think, oh, that was unfortunate, that you can talk about?
Not really. I mean, I again, to return to a previous something we talked about previously, level of skill's pretty good. There's laws like everything else. There's some people are better at it than others. Let's use neutral language here. But I don't know that I'm trying to think, and honestly, I'm not sure I've ever seen a point of friction between a junior lawyer and a senior lawyer.
Right. And that's great. That's very reassuring, I think, for those juniors that are going in, that it's very unlikely they're going to step, into something that's going to not represent themselves well. So if somebody's listening and they think, I want to get into litigation and I actually ultimately want to get into mediation or arbitration for that matter, what would be the trajectory for them? Because my sense, Mark, is that one needs a lot of experience in disputes in general before they can step in as that neutral mediator. But I might have that wrong.
Well, it's a good question.
And maybe it's
so. I'll just tell you at the end of the day, I have this belief that all I can really share is my own story. I can't share other people's stories. So my story is that I practiced law for a really long time. I was called in 1982. I did my first mediation in 2004 and non-practicing 2015. Yeah, I think your folks heard that. So I've been mediating now for 20 years. I can tell you that my 20 plus years of practicing as a lawyer certainly informs the way I work as a mediator. Mm-hmm. But nothing informs the way I work as a mediator more than 20 years practice as a mediator.
Right.
So is that
right?
It's a roundup. That's my experience.
Right.
I couldn't do what I do without substantial litigation experience. I just couldn't.
Okay, so that makes sense. And certainly there are probably mediators who have less experience who are trying to get into mediation and build a practice for themselves, which is a lot of work. I know in the marketing realm, you've done a lot of work in the early years, really hit the pavement. You really worked hard. I've seen that firsthand. Why do you think mediation skills will accelerate a legal career early on? Getting those juniors in the room, having them witness what's going on, having them observe, having them appreciate the process. Would it be your recommendation that they get in the room as frequently as possible?
Yes, I mean it's is, you touched on at the beginning, it's the most widely used means of resolving civil matters.
Mm-hmm.
And it involves a different application of the same lawyer skill set, but it's still a different application.
Right.
So, like me doing it for 20 years and having seen a thing or two now, it's helpful to experience neutral mediations are like. It's one of the things I love about my job. Like, no 2 days are the same. And I can also tell you, somewhat hyperbolically, but not entirely, the minute I think, oh, this could be an easy day, I'm doomed to a not easy day. Not that I particularly want easy days or easy days are better or whatever, but if I think, oh, this is smooth sailing, we got this. No, it's not smooth sailing, and we haven't got it. So
that's interesting, Mark. So never underestimate what you're getting into. Never presuppose what the parties are going to bring, right?
Never.
Never.
No
Because
assumptions.
you never know what you're going to get.
No assumptions. I prepare meticulously for whatever I'm doing, and I still get curveballs. Like where I go, no. Like, why didn't somebody tell me that? I did a residential construction mediation involving a construction of a private residence. They are the family law of construction litigation, just in case you didn't know. And I can't figure out why the male homeowner will not be in the same room as the contractor. And I'm going, well, that's very odd. And then I find out 2/3 of the way through the mediation is because his wife had an affair with the contractor during the course of the construction of the home. And no one thought to tell me that. And I'm going, like, why? Why wouldn't you tell me that? So you never know. Like, you just never know.
Right.
And it's one of the things I love about my job.
Yes. And thank God you're so well prepared for the
Gotta be
curveballs that you
prepared.
think you can anticipate, right?
You gotta be, you're the, how do you put it? How am I going to put it? The preparation on everything you know assists you tremendously when you have to deal with something you don't know, because you're not worrying about the stuff that you could have known. You're just dealing with the stuff that you didn't know.
Right. It's like preparing for trial, right? I guess.
Like preparing for trial. It's no different.
Quick questions for you, Mark. What do you wish you knew about mediation when you were a young lawyer?
Ooh. That it called for a different form of advocacy. That you were advocating for your client, but advocating based upon a risk-driven analysis as opposed to a who's right, who's wrong analysis.
Excellent answer.
Not bad, huh?
No, excellent answer. And you weren't prepared for this question, so that's an excellent answer.
I wasn't. I thought, yeah.
If you're a student sitting in a mediation, is there anything in particular that you should be watching for?
Yes. Pay particular attention to the parties' body language reaction at parts where it's difficult, either from an emotional point of view, or someone's saying they're wrong, or that someone's taking issue with something somebody said. Pay particular attention to that.
Can I take that a step further? I love that, because I think that would be really interesting, because it's almost like watching a drama unfold in front of you. So once you observe that, then I would look to the mediator to see how is the mediator handling that? What is their response to what because certainly they're observing the same thing that I am as a junior in the room.
Now, you may not see what the mediator does. I would tend to handle that discreetly without the other side there. So if it's your client, absolutely. But if it's the other side's client, you may not see what the mediator does. You may not necessarily see what I do, because I would tend to handle that separately.
Oh, I see. Okay. Separately, meaning privately.
Yeah, privately.
Privately. Okay. So you wouldn't actually see it. Okay. Is mediation about psychology more than law?
say often psychological exercise driven by legal principles.
Mm.
How's that?
Mm-hmm.
No one's going to throw law out the window,
Mm-hmm.
except when they do. Some people, again, you never know what's going to happen. The reasons people resolve cases often have nothing to do with what the law is, but maybe they're tired of it. Maybe they're tired of the litigation. Maybe they want to see the people again. Maybe they don't want to. I'll give you a good example. I mediated a sale of a business case just years ago, and the woman who bought the business and her lawyer were sitting in a room waiting for the other side to do something, and they have trial coming up, 15 days of trial or 10 days of trial, and I said, so what do you? I learned during the course of the day she had a 4-year-old and a 2-year-old, whatever it was. I said, what are you going to do with your kids during the trial? She looked at me and said, I have to go to the trial. I have to be in trial for 2 weeks. And I said, well, ask your lawyer, Mr. Jones, about that, but I'm pretty sure he's going to want you there. The whole dynamic changed.
Wow. Really?
Whole
Wow.
dynamic changed. So you never know.
Wow.
But it starts off as there's some legal principles involved.
Yes.
Why it resolves may have something to do with the law, but might not.
Yes. Does assertiveness in the mediation room help or hinder?
Depends. I think the best counsel at mediations are very good at simply saying, this is my point of view. My view on this issue is X. I appreciate we have a difference. I appreciate we're not going to agree on it, but this is my view. And unless there's some recognition that there's risk to you, that my view is accepted, we don't really have a whole lot to talk about. So I don't know that that's assertive so much as just plain language. This is my position, and this is a stumbling block if we can't get there.
Right. And if somebody starts to get aggressive, I guess the role of the mediator is just to try to neutralize that aggression.
Yeah, or sometimes you just got to let it run.
Run its course.
Depends.
Right. Because you're trying to resolve that mediation in that one day, right? Or
yeah,
can it go
so yes, except though that the nature of my work these days is often I have things that are ongoing, where we'll spend a day and we won't get very far, or we'll make some progress, we won't get there, and I'll keep dealing with the parties afterwards. If I touch wood, I don't have anything like that right now, but at any given point in time, I've got things that are ongoing.
So does a mediation ever continue outside of the room?
Oh, yes.
So, okay, so you're communicating outside of the room by email, phone, what have you, separately?
Email, phone,
okay.
Sometimes with both parties, sometimes independently,
okay.
To just carry on talking.
Right, okay. I actually didn't appreciate that, but that makes a lot of sense now that we're talking about it. Anything else that we need to know? Do you find that people are surprised at the process, those that are less familiar with mediation, that it's such a skill that they get in the room with you, they might sit back and go, wow, this, is really anxious about this. It might be a little of a gentler process than being in a courtroom. And they feel, I don't know if you get this feedback, Mark, but do you suspect people feel like it's a little easier than they expected, even though it's still uncomfortable and they're kind of trying to come to a resolution? Would that be a fair statement?
Yeah, I was very fortunate. There's a youngish lawyer who I did a mediation with, and she phoned me afterward and said, that was my very first mediation. And I said, oh, I'm honored that I was mediating the very first mediation. And I wouldn't have known it. She'd obviously prepared well.
Yeah.
She knew her case. She'd obviously, there's no way she would have intuitively known how to handle herself the way she'd handled herself. So my guess is she'd been at a bunch of mediations prior, and she's a good firm with a good firm, and she'd seen skilled people at mediation. So she got some of that. So it was a bit of a moment. I was quite,
That's lovely. I love
yeah,
that.
it was
That's
great.
great. That's always great to get good feedback. It
I
can,
was pleased she phoned me afterwards and told me. Otherwise, I wouldn't have.
yeah, yeah,
So
yeah. I love that so much. So it kind of brings us back to what we were talking about earlier in that get in the room, observe as a junior as much as you can, be as part of the process as much as you can, as
yes,
much as your senior lawyer will.
and when it comes time to do your first sole mediation, don't be afraid to share that with the mediator ahead of time,
Oh,
because maybe the mediator can provide you with some useful tips. Maybe the mediator can say, you know what, I've dealt with the other lawyer before, and I can tell you this might be a problem. So you might want to think about that. So share with the mediator.
interesting tip. Okay, so if it's your first mediation, tell the mediator it's your first mediation and they might be able to give you
They
some
might be able to
tips.
assist, tell you some things that you don't know.
Fantastic advice. Or you've only done a few mediations. Maybe it's not just your
Yeah,
first, but you've only done a few mediations, or maybe you're particularly nervous, or you have a combative client. I mean, that could
that's
be
right.
that too, right? You could,
Yeah. So part of my regular process is to have calls with the lawyers before the mediation. So after I've got the briefs, but before the mediation proper, I'll always phone up and say, okay, what's really going on here? Is your client listening to you? Is your client flexible? How's your relationship with the other lawyer? Have you had previous cases with the other lawyer? All those sorts of things. Where do you think this is headed? They have this issue here. What's your real take on that issue? And so I always have a discussion ahead of time.
so the more they disclose to you as a mediator, the better,
Yeah, totally.
it would seem to
And
me.
and remember, at least in my mediations, anything shared privately with the mediator is private.
You're not sharing it with the other side,
Not sharing with the other side.
confidential, neutral party,
Confidential, neutral.
right? And that your interest is only to get those people in the room,
Right.
literally or virtually, and get to a resolution.
Right.
Right. And that's probably why you continue to get hired by the same lawyers, Mark. That's probably why, is that you have established that trust.
Probably.
So you have done a huge span of types of mediation. You've done, I don't know, this is a layperson's term, but what you might think is a more straightforward, simple dispute, right through to these complex aviation. I know you do some really naughty, I don't mean not like naughty, difficult, complex, multi-party sorts of things. And you prepare well for both types. Is it the same process? Is it just some or no?
Same process.
So it is the same process.
Sometimes more bells and whistles.
Yeah. Yeah.
The more complex the matter, the more work I have ahead of time before the mediation proper to sort out things that can be sorted out ahead of time.
So you might have multiple calls with both parties. You are maybe doing independent research. Do you doing independent research? You're only looking what you're provided.
Only looking at what I'm presented with.
Okay.
I'll sometimes ask for more information. Depending. But the more complex the matter, for example, I was just retained do a mediation of a class action case in Alberta. Mediation is set for June, and it's complicated it's complicated case to begin with, but it's got some complications from a process point of view right out of the gate. So I started making calls. Talked to plaintiff's counsel, talked to 2 of 3 defense counsel, and coming from that, I'm going to go to them and I'm going to say, okay, this is what I think the lay of the land is. I think we should be focused on this as we move forward. What do you think? And go from there.
So is it similar for those lawyers as if they're preparing for trial?
I guess to the extent that they're trying to do everything that's necessary, that they're ready. Yeah.
Mm-hmm. Mm-hmm. So it's no less work. It's no less work.
You want to be ready. You don't want surprises.
Yeah. Yeah.
The surprises are seldom helpful at a mediation.
Well, and I suppose it can become more costly for a client.
Yeah,
right?
it's surprises that could have been avoided are seldom helpful.
Yeah. Yeah. Interesting. Well, anything else that occurs to you that we should learn from you
No, we
about
covered a lot.
mediation? We've covered a lot. I know this has been really great, Mark, really great. And
Thank you.
I continue to celebrate your career. It's been such a joy watching you get
Thank
into the
you.
position and get into these really interesting rooms and do the great work that you do. So
Yeah, I'm very, gratitude is a guiding principle in my life, and I am very grateful for what I get to do. That's the
well, and
way.
I think gratitude is great. I think it's come with a lot of hard work too, and a lot of marketing and a lot of skill development and a lot of trust building. So I know it's come with a lot of hard work. So thank you, Mark, for sharing
Thank
your
you very much.
insight. And
Thanks.
I know that when there's juniors in the room in any of your mediations, they'll know that you know what
Oh,
their role is.
I always inquire how things are going with juniors
Excellent. They can ask questions too,
and
right? Of the
and
mediator.
students. Students always get the it's time to is there's still time to change your mind line.
Yeah, right.
Anyway, all right. Thanks,
Thank you,
Susan.
Mark. Thank you
Thank
so
you.
much.
Okay.
Stay tuned for our Lawyer Launcher debrief. Wasn't that great? Oh, Mark is full of tips and stories and insights. And I just thought it was a great conversation. And some of the things I really appreciate about Mark, as I have my whole career as I've known him, is to be somebody who's got a lot of heart. He's got a lot of emotional intelligence around the work that he does and very little ego. He's somebody that has, some might say, earned the right to have a bit of an ego, but he continues to show up as somebody who's not only neutral and professional, but somebody who doesn't, he doesn't lead with his ego. And I really appreciate that about him. And it's probably one of the reasons why he is so successful is that he's so likable and he's so accessible and people really relate to him. He's super bright. He's very well prepared. He doesn't take anything for granted. And I loved his moment of gratitude about the work that he does. And I got to say, I know him personally. When I see him, he is very much how he showed up in this podcast. He's very humble, very grateful, very lit up and excited about the work that he does. So if mediation is something that might be in your future, bookmark this podcast, come back to it, because I think it might be meaningful to you as you move through your career, or certainly as you attend your first mediation with your client. There's some good tips in there. And please share this podcast. I think it can help a lot of people, perhaps some clients, certainly some counsel, and most definitely some junior people going into a mediation room for the first time. I'm glad you joined us. See you next time.